सुमित इधर जाओ जल्दी। तुम जाओ, तुम अभी कुछ नहीं करोगे।
चार नहीं मतलब काफ़ी छोड़नी पड़ेगी ये वाली रोड जहाँ पर वो बैठे उनको मैं बुलाता हूँ कि और किसी को फोन करना।
तो है
वो स्ट्रीम का शेयर मैसेज भेज दिए।
इसको ऐसे कर मेरा बहुत
अभी तो ज्वाइन ही नहीं किया किसी ने, ठीक है।
The teams are requested to inform about the team code and track limit. I should remind you after 10 minutes, 5 minutes, 2 minutes, and then the time will be out. And I will shift my place after this further, and so that it will be easier for you to work. All the best. Greetings to the family. The company permission to address the presence to your honor. May it please your honor, this is council number 09, appearing on behalf of appellants in the matters of Union Bank of Kurukshetra, State Bank of Kurukshetra, Pilots Union and Aircraft Lessors versus Neil, Air Hastinapur and Bishop Acid Reconstruction Company. Your honor, if I may elaborate the facts of the case for reference. In the present case, Air Hastinapur is a part of conglomerate group of companies, Hastinapur Group. It is an airline company with a fleet of 129 aircraft leased from various international aircraft lessors. During the family division of business, the airline company came under the leadership of Yudhishthir and Arjun. During the times of COVID, all the sectors of the business faced financial instability, including Air Hastinapur. And that is why they filed an application under Section 10 of the Insolvency and Bankruptcy Code. Your Honor, Air Hastinapur issued bonds to grow and sustain their green energy business. It has a total liability to the tune of 5,000 crore rupees, which is owed to various financial and operational creditors. In the present case, the financial creditors filed an application under Section 7, which was rejected by the NCLT. The operational creditors filed an application under Section 9, which was also rejected by the NCLT. The Union Bank of Kurukshetra filed an application under Section 65, alleging that the application under Section 10 is malicious in nature, and this was also rejected by the NCLT. NCLT only admitted Section 10 application, appointed me as an insolvency resolution professional, and imposed moratorium. Thus is the present case. Your Honor, if I have your permission, may I move to the issues for consideration? Here there are 4 issues for consideration. I will be dealing with issues pertaining to Section 10, that is issue 1, and issue 3 pertaining to Section 9. And my learned friend will be dealing with issues pertaining to Section 7, that is issue 2, and Section 65, that is issue 4. Your Honor, if I may proceed with my arguments. Herein, the first issue for consideration is whether the NCLT erred by admitting the application under Section 10 of the Insolvency and Bankruptcy Code. The Council humbly submits that the NCLT erred by admitting the application under Section 10 because of 2 primary reasons. First, it causes irreparable harm and injury to the creditors, and secondly, the application was filed with a malicious intention. Your Honor, before moving on to my arguments, I would like to highlight before this court that the Section 10 application was not required at all in the present case. Because I would like to highlight the case of Air India, wherein the central government has issued various financial schemes specifically for airline industry. Your Honor, if I may draw your attention to page number 1 of the compendium. Page number 2 of the compendium, it gives the financial assistance given to Air India. The central government has rolled out various financial schemes for rehabilitation of airline industry. Your Honor, if I may draw your attention to page number 2 and 7 of the compendium, it has given a bailout package which the government has given to Air India. Also, Your Honor, the government has released various relief packages for the airline industry. in the recent insolvency cases also of SpiceJet, Jet Airways, the government. Much obliged, Your Honor. Your Honor, the chairperson, Your Honor, I'm the council pleasing on this. Your Honor, NCLT is a fast-track court and it takes summary proceedings. So, Your Honor, the insolvency cases are very time-sensitive. So, they need to be resolved as early as possible, and that is why NCLT was set up to take up these commercial matters because they are very time-sensitive.
Indian Constitution has any provision for establishment of tribunal?
Yes, Your Honor. There is, it is stated in the Constitution. However, I am not aware of the exact article, but I assure you that it is provided in the Constitution.
From beginning or it has come by
Your Honor, it is from the beginning. Yes, Your Honor. It is from the beginning. The Constitution was.
Can you name the Constitution law books?
Your Honor, Constitution law books. I am aware about MP Jain, the written on Constitutional law, and
All right, proceed.
much obliged, Your Honor. So herein, before filing application under Section 10, the airline company must have gone to the central government to seek these financial assistances, which was not done by Air Hastinapur. Your Honor, now I will move on to prove that.
Strengthen your argument, the point which you have said. Has to go to just have gone to the central law. That is argument you have made.
Yes, Your Honor.
What is the authority?
Your Honor, there is no authority. However, this has become an established industrial practice. If we look into the recent past insolvency cases, yes, Your Honor. If I may draw your attention to Your Honor, page 6 of the compendium, it basically gives the central government has released a press information bureau report for revival of the aviation sector. Herein they have specifically stated that they will take steps.
So can we consider the PIB note is authority or something?
Your Honor, this is a notification issued by the government. This is not mandatory, however, this is directory.
Is notification a law?
Your Honor, yes, notification, it becomes a law. Your Honor, it is in furtherance of the law, it aids the law. It is not exactly
According to Article 13 of the Constitution.
Article 13. Yes, Your Honor. So, Your Honor, this is a revival plan issued by the central government, and by the virtue of this, they should have gone first to take the financial assistance. Now, Your Honor, I will prove that why this application is malicious in nature. Your Honor, firstly, my first reasoning is that it causes irreparable harm and injury to the creditors. Your Honor, I would like to draw your attention. It has been stated that he was appointed as an interim resolution professional. Your Honor, we challenge the appointment of Bhim as an IRP because he is not eligible to be appointed as an IRP under Regulation 3 of the ITBI Insolvency of Corporate Persons Rules 2016. It specifically states that to be appointed as an IRP, they have to be independent of the corporate debtor, and there are 3 conditions stated. If I may draw your attention to Regulation 3 of the Insolvency ITBI Rules 2016. It states that a person shall be considered. Do I have the attention, please? A person shall be considered independent of the corporate debtor if he is eligible to be appointed as an independent director on the Board of Corporate Debtor under Section 149 of the Companies Act. Your Honor, he is disqualified under Section 149 of the Companies Act because he is not independent of the corporate tender. Your Honor, if I may draw your attention to Moot proposition, it has been clearly stated that he has served as the chief auditor of the entire Air Hastinapur Group. Your Honor, this basically makes him a related party due to the access of all the information which he has of the books of accounts of the company. So, Your Honor, by appointing him as an IRP, there will be a biasness in the whole resolution process which will be detrimental to the interest of all the creditors. Your Honor, Your Honor, he is a related party because he brings in biasness. Your Honor, if I may highlight.
Related party is a defined term.
Yes.
How do you fit it into the regulation?
Your Honor, related party is defined under section 5 clause 24 of the Insolvency and Bankruptcy Code.
Clearly because he had been the CEO of the company earlier. So is he a related party today? What has to be seen is he a related party in present time. That is as of now.
Right, Your Honor.
If 20 years back he was my CEO, does it make him a related party?
Yes, Your Honor, for this, I appraise your point. I acknowledge your point. In the case, I would like to highlight the case of Phoenix, where it has been clearly stated that the whole circumstances must be looked into and not only the present circumstances.
Phoenix also says the circumstances are to be seen in present time. That's the spirit of Phoenix.
Your Honor, however,
History is irrelevant.
Your Honor, however, it has also been laid down that the circumstances as a whole should be seen. Your Honor, I would like to highlight another case, SBI versus McIntyre.
Can you point out any observation in Phoenix which will cover your ground?
Much obliged, Your Honor. I would draw your attention to the page 188 of the compendium. Your Honor, if I may have your attention at paragraph H, it states that it would appear that the use of simple present tense in the first proviso of section 21 clause 2 indicates that disqualification applies in present time. Furthermore, this interpretation would also be supported by reading of first proviso. Your Honor, however, this is a very mechanical interpretation of the words. Further, it also noted that if we have to take the purposive, constructive interpretation, then we should look at the whole picture and like what is the purpose of having this provision to remove the biasness. So, in order to give effect to the spirit of the law, we have to see the whole picture, and if the biasness is being crept in from any of the potential sides, then he has to be removed or the application can be challenged. Also, Your Honor, in the furtherance of the same, I would like to highlight the case of SBI versus McIntyre, which has also been provided in the compendium. Therein, the person who was proposed to be an IRP, he was removed on the likelihood of bias because he was a previous employee of the company. So, Your Honor, he was removed. So, we follow this precedent. So, Your Honor, we challenge this case on the basis of invalid appointment of interim resolution professional. Now, to move further, I submit that the application has been filed maliciously because I would like to draw your attention to page to Moot proposition para 12, wherein it is clearly stated that in the trust assigned its debt to asset reconstruction company. Your Honor, I would like to highlight that Indraprastha is the largest creditor and it has and we owe to them 50% of the debt, that is 2500 crores. Indraprastha is a related party because Indraprastha and Air Hastinapur are a part of same Yudhishthir group, which has also been highlighted in the clarifications. They are a part of same Yudhishthir group. So Indraprastha is a related party. Your Honor, by the virtue of section 21 of the code, which excludes a related party from participating in the COC, Indraprastha would have been excluded. That is why they have assigned their debts to the asset reconstruction company. Your Honor, also the asset reconstruction company is headed by Indra, which has been highlighted in the proposition. And Indra has served as the CFO of the energy enterprises. So we contend that ARC brings in bias, ARC will represent the interest of the corporate debtor, that is Air Hastinapur. Because Indraprastha is a related party of Air Hastinapur, they have assigned their debts to ARC because they will be disqualified for participating in COC. So to take a backdoor, Your Honor, we want to prove that they are a related party, and all of this has been done maliciously. Your Honor, there have been patina of cases which state thank you, Your Honor. Your Honor, I would like to highlight that Indra, who has served as a CFO of the entire of the green energy sector. Your Honor, CFO falls in the key managerial, in the category of being a key managerial person under section 203 of the Companies Act. And Your Honor, related section 5 clause 24 clause B of the IBC, it specifically states that any KMP will be of the corporate debtor or any financial creditor will be a related party in the case. So Your Honor, by the virtue of section 5 clause 24 clause B and section 203 of the Companies Act, we contend that Indra becomes a related party in the present case. So Your Honor, they will be representing the interests of Air Hastinapur. That is why all of this has been done maliciously, and the application under section 10 must be rejected by this honorable tribunal. Your Honor, I would also like to highlight, if I may draw your attention to page number 1 of the written compendium, we have submitted a calculation sheet. Your Honor, it shows that since Indraprastha is ousted from the COC and they have transferred 50% of their debts to ARC. Now, financial committee of creditors is comprised of financial creditors, and by the virtue of section 21 clause 4, all the financial get a voting share in proportion to their debts. So Your Honor, when this 50% is converted into the voting share, it amounts to 66.75%. So Your Honor, this shows that the entire process of the CIRP will be hijacked and hijacked by one group, and they will not be able to take any other decision other than the interest of the corporate debtor. Your Honor, is the bench with me? So Your Honor, this whole and even if they want to change the IRP, in case the tribunal proposes to change the IRP under section 27, it also states that there has to be a consent of 66% of the in the committee of creditors, of financial creditors. So Your Honor, herein they hold a voting share of 66.75% alone. So they will have the control over the whole of composition and the working of the COC. That is why section 10 application is malicious and it must be rejected by this honorable tribunal. If Your Honor has no further questions, I will move to my second prong of my argument.
Can I ask a question? If the section 10 is admitted, then what is the provision under which the regulation can be revoked or involved by the minister?
What is the Your Honor, under section 10 clause 4, NCLAT has the power to reject the section 10 application if it is incomplete or if the grounds are not fulfilled.
After or just an admission of section 10 to an
Your Honor, admission, then we can approach it and plan. Your Honor, if I may move to the second sub-issue or first issue. Your Honor, if I may seek permission to move to my third issue in the light of paucity of time. The third issue is pertaining to whether the NCLT was incorrect in dismissing the application under Section 9 filed by the pilot's union. Your Honor, I would like to highlight in the Moot proposition para 19. So, Your Honor, we contend that we have a valid locus to file this application. India Airways, it has been clearly laid down that pilots fall within the domain of the workmen. So, Your Honor, it is established that pilots are workmen. Moving on, Section 9, these workmen fall within the domain of being operational creditors. Your Honor, by the virtue of Section 5 clause 20, read along with 5 clause 21 of the Code, workmen fall within the virtue of being operational creditors. So, Your Honor, operational creditors are given an explicit right to file the application under Section 9. That is why we have the locus, specific locus to file this application. Your Honor,
Counsel, how do you agree that it is as long as the other petition is with the outcome is the same? Supposing your petition was also with you, what would be so different?
Your Honor, may I seek an extension of 2 minutes? Your Honor, has raised a question is admitted.
On one hand, you are opposing the admission that Section 10 should not have been admitted. On the other hand, you are arguing the workmen union that arbitration should have been admitted. Supposing this one was admitted and that one wasn't, would the result be any different?
No, Your Honor. Apologies. No, Your Honor. The result would have been same. However, under Section 9, we would get the right to appoint our own interim resolution professional. Your Honor, in the present case, the application was under Section 10 is filed maliciously, and we want to raise the point that Yudhishthir and Arjun, who are the owners of the company, they have no plans of revival for the company because they have issued, as I highlighted, they have issued green bonds to finance other businesses, which shows a lack of intent to continue this business. Your Honor, if application under Section 9 is admitted, we would appoint our own IRP and we would like to take the control of the company and ensure its revival. That is why, Your Honor, we have filed the application under Section 9. And
See, the petitioner never takes control of the company. Control of the company goes to the RP. It is a misnomer to say that we have our own RP. Nobody has their own RP. RP is supposed to be absolutely independent discussion.
right, I agree with Your Honor's point. However, as I highlighted, they have no intention to revive the company and we want to revive the company.
See, even if you recommend your RP, that recommendation is endorsed, that RP will be replaced in the first season.
Right, Your Honor. I agree with your concern. However, for this, I would like to highlight that we contended that ARC will represent the interests of COC. Your Honor, if we establish that ARC is also a related party, as I said, interest related party, they can also be excluded from the COC. And
that
then,
petition is always open to you.
yes, sir.
Once the petition is admitted, ARC will not be sitting in COC. That petition is always open.
Your Honor, may I seek an extension?
Yeah,
Your Honor, I will answer your.
you can do.
Your Honor, I will answer your question. That yes, then ARC will be a related party, and we will remove them from the COC. And then Union Bank of Kurukshetra will have more than 90% of the representation in COC, and we all aim for revival of the revival can be ensured. That is why we have come under section 9. So, Your Honor, if I may summarize my arguments. We have pleaded that under section 10, issue 1, application under section 10 must be rejected because it has been filed maliciously, and the pilots and the application of the pilots union must be considered afresh because it was dismissed on the lines of locus, and we have a valid locus. Your Honor, if it is dismissed on the basis of locus, then it will set a bad precedent for filing cases in the future on our behalf. That is why, Your Honor, we submit this. It was an honor argument for us. Now,
this one of the issue. Lordships never raise contentions. The always observe. You will see contentions. Lordships will never raise contentions. I wish the Lordships would raise contentions.
my apologies, Your Honor. My apologies.
No. This is what it is.
Now I would like to hand over to my learned friend.
Your Honor, this is Council number 09, appearing on behalf of appellants in the present matter. Your Honor, I shall be addressing the issue number 17, which is related to section 7 filed by State Bank of Initiative.
Housing code or team code issue?
Team code is open.
On housing.
It's apology. Your Honor, I shall be representing the interest of State Bank of Initiative, which is issue number 2. I shall also be representing the interest of Union Bank of Initiative under issue 2. If I have the permission to begin with my issue number 2, I shall be representing the interest of State Bank of Initiative. Your Honor, our humble submission under issue number 2, that is dismissal of application under section 7 filed by State Bank of Initiative, is erroneous in law and is not justified. Your Honor, I shall be proving my point by two main arguments. Coming to the first argument, Your Honor. Your Honor, section 7 application filed by the State Bank of Initiative was not based on the RBI circular, which has been declared null and void by the Dharani judgment. Your Honor, if I may have your Honor's attention to fact sheet, para 19.3, Your Honor, 19C, Your Honor. In that, it has been mentioned that the NCLT has dismissed our application on the basis that Dharani judgment has given the RBI circular as void, and any application based on that circular shall be null and void. Your Honor, our humble Your Honor, right, as it has been declared void by you have a case law, I seek your Honor's attention to page 99 of the comparative conflict. That is SBI versus Rohit Fire Act. Your Honor, this is the learned tribunal incorrect decision, which has been later upheld by Supreme Court also. Do I have the bench with me, Your Honor? Your Honor, kindly refer to page number 100, Your Honor, para 11, last. Your Honor, I went for having another copy, but the shop was closed, so I could not get one. So it's humble apology. Your Honor, in para 11, petition under section 7 of IP code is to be considered by the adjudicating authority on its own merits, taking into consideration the records and in absence of any evidence to show that the State Bank of India filed an application only because of circular issued by RBI, it was not open to adjudicating authority to reject the application. This was the decision, Your Honor. Kindly refer to page 99, para 5. From the record, we find that the application by section 7 of IP code was not filed by State Bank of India pursuant to circular. Para 6, Your Honor, the corporate debtor has not made any request for restructuring of its loan as per the guideline. I'm sorry for misspeaking, Your Honor. I just want to read the line of the Reserve Bank of India circular. Your Honor, these facts directly pertain to present matter, as in the present case the debt, Your Honor. Henceforth, there was no other way, no other remedy available for State Bank of Kurukshetra to file an application other than Section 7. Henceforth, our case that we have filed our petition under Section 7, Your Honor. Your Honor, I do also have a case which is kindly refer to page 105 of the compendium, Your Honor. That is Ankit Patni versus State Bank of India, Your Honor. Your Honor, do I have the bench with me? Your Honor, in this case also, a Section 7 application was rejected on the basis that it was filed on the basis of the circular. Their court observed, kindly refer to para 14, Your Honor. It is clear that they are not applicable in the present case. The 13 June 2017 circular only provides direction for initiating corporate insolvency resolution process under the IP Code. The 12 February 2018 circular has come into effect after filing of application in Section 7. Your Honor, kindly refer to para 15. The directions of RBI also suggest that the RBI never intended to interfere with the statutory remedies provided in Section 7 of IP Code. And so, Your Honor, our humble submission to this. Yes, Your Honor. Your Honor, it has been the position of law that Supreme Court decision are a binding precedent. Respectfully, Your Honor, there is a hierarchy of courts in which the Supreme Court is at the. Yes, Your Honor. True, Your Honor. Your Honor, right now I am not able to collect my thoughts on that because I am so occupied with this. I humbly I apologize for this. However, Your Honor, Your Honor, our humble submission before this tribunal is this: that the NCLT has normally rejected our application, saying that it was based on the IS and certain different cases, as well as the situation also, we have not raised our application on that circuit. Now coming to the second main argument, Your Honor, that is our Section 7 application was complete and it was rejected without valid ground. Your Honor, for this, Your Honor, under Section 7, there are two main necessities. The first one is the debt and the second is default. The existence of debt and default are the prerequisite for filing Section 7 application. Your Honor, in the present case, default, debt and default are present. Your Honor, if I may have Your Honor's attention, page 9900 of the compendium. It is the observation. It is the innovative industries case, Your Honor, that is page 100, Your Honor. The moment the adjudicating authority is satisfied that the default has occurred, the application must be admitted unless it is incomplete. Your Honor, our humble submission is this only, that there is a debt, there is a default, and our application is complete. There is no disciplinary proceedings going against the proposed IRP that we are proposing. Henceforth, it becomes necessary to admit our Section 7 application. And they have rejected our application without giving any grounds, without any grounds. This is our case, Your Honor. Your Honor, it has been the position of Supreme Court also that once a default has been proved, thereafter the discussion with the NCLT to reject the Section 7 application is strongly curtailed. This has been given by the Suresh Kumar Reddy versus Canara Bank. I have that case in my compendium also, Your Honor, on page 121, para 1. The Supreme Court gave its observation on this. Henceforth, Your Honor, our case is this: that our Section 7 application was complete. It was not based on the circular, and so it should be accepted. Now, dealing with the issue that the other party is raising, that their Section 10 application must be accepted. Your Honor, for that, I do have a simple observation that as argued by my learned friend also, that Section 10 application was maliciously filed and it was not complete. Your Honor, Section 10 clause 4 of the IP Code specifically mentions that a Section 10 application must be complete, and if it is not complete, then it is going to be rejected. Your Honor, our case is this only, that as the IRP, which proposed IRP under Section 10 their application becomes incomplete. Therefore, Your Honor, our application under Section 7 is complete and it must be accepted because to save the time as well as to save the deprivation of assets. Do I have the bench with me, Your Honor? If Your Honor there is no further question, I shall move to my.
I have a question.
Yes, Your Honor.
Same question that I put to you last part. Your grievances section 10 has been wrongly admitted. 7 has been wrongly verified.
Yes, Your Honor.
Right?
Your Honor, I am representing the interest of State Bank of Maharashtra.
That's right. So law petition has been wrongly rejected and section 10 petition filed by the CP has been wrongly rejected.
Yes, Your Honor.
Supposing your petition was admitted to you,
Yes, Your Honor.
would the result be any different?
No, Your Honor.
Then how are you agreed?
Your Honor, we are agreed as we are the financial creditors of the corporate.
So how are you agreed by this admission? You yourself are asking for admission of this petition.
Yes,
The
Your Honor.
result is the same.
Yes, Your Honor.
Your petition has not been admitted, somebody else's petition has been admitted.
Yes, Your Honor.
So how are you agreed to that result?
Yes, Your Honor. If I may answer your please. Your Honor, as argued by my friend, by our learned friend, that section sub proposed IRP is a related part.
So that's the only
That
difference.
is
You
the
did not give an RP of your choice.
Yes, Your Honor.
That's
Now
the
coming to
only
the second form of the argument. That is, IRP can be changed under section 27. However, for that we need a resolution, a support vote of 66.75%. As provided in the calculation sheet in the companion document. If we see, they will have the interest, their interest will be represented by ARC and it was
ARC is disqualified.
Yes, Your
Will
Honor.
not be part of the case.
This is something which come to the notice of the bench only when we raise this one. Hence our first contention is to that it is an irrelated part. Your Honor, that is why if it is removed, then we will have around 90% of completion because there are two major financial
Do
categories.
you think the underlying intent of IBC is to petitioner a choice of picking up a particular person as an RP?
Your Honor, they have proposed a name which is
You can
related.
only propose. Is the underlying intent of IBC to give you that choice?
No, Your Honor. Your Honor, as mentioned in code
And how
also.
can this be a grievance that I don't have an RP in my hands?
No, Your Honor, we are not agreed by the fact that we are not having an RP of our choice. We are okay with RP. However, we are questioning the eligibility as well as the independence of the RP. The RP who will be appointed, he will be representing the interest of the corporate debtor. Henceforth, we are proposing that it is okay for us to appoint any RP, other RP, and independent RP. However, that should represent the interest of creditors also. Like he should be independent to take decisions without any bias towards any party. That is our major concern also. And that is why we are filing. Your Honor, also there is a contention that why we are coming for section 7 and 10 has been accepted. Your Honor, our application was wrongly rejected on wrong grounds. And we as a public sector undertaking have to come under before this tribunal to have the right decision because that will set a wrong precedent value. In future, if we file any of the cases, then the court will reject our application on the basis of this, on the ancillary decision. And as a public sector undertaking, we do have very, it will set a wrong precedent against us. Your Honor, we are a public sector.
Bench has all the right to say this in your facts and circumstances.
Yes, Your Honor.
There will not be a precedent.
However, that becomes very wrong precedent in future also for us.
It will not be because you say that in such peculiar facts and circumstances. it will be.
So are you okay if the approach says that our practice will not constitute a binding precedent? Our addition is that.
If Your Honor specifically mentioned that in the order sheet, we are okay with it. However, that has not been mentioned. And
No, in the appeal, the appeal court was to say our practice will not constitute a binding precedent. This question is only academic now, and this appeal is practice.
Your Honor, as that is our second condition. Our first condition is still the same that the proposed IRP is malicious and is not eligible. Henceforth, we are challenging section 10 and we are going for section 7. We want an IRP who is independent and
What is your basis for saying that he is not illegal?
Your Honor, as referred section regulation 3 of appointment of insolvency resolution process for corporate person specifically mentioned that if a person shall an IRP definition that what is independent. They have taken a definition from in the explanation part is eligible to be appointed as the independent director of the company. Now they have also mentioned there are three conditions and it is important to fulfill all the three conditions. He is not fulfilling the first as well as second. He is a related party as he has served as the chief auditor of the firm. Your Honor, there is no specific mention of years and also as argued by a learned friend that we have to take the full picture into consideration. Your Honor, we have also submitted a case of SBI here where the court specifically observed this fact. There are two specific observations in that case, Your Honor. First, yes, Your Honor. Your Honor, the first observation of the court was that the reasonableness of bias must be taken from the third party. We, the third party, have a strong apprehension that they will be biased. Your Honor, the second thing is the court specifically ordered that this IIT cannot be appointed because he was an ex-employee and he will represent the nation. Hence, what our case is this, Your Honor. Your Honor, I do have some facts which shows that they are on the intention to defraud the creditors right from the. Your Honor, if I may have your Honor's attention on para 4, 5, Your Honor. Para 6, Your Honor. Para 6 on Moot proposition. Your Honor, the second line, they are finding it nearly impossible to sustain the airline and are concerned that the damage will spill over onto their other business ventures, especially the green energy sector. That is the first point.
Which paragraph mentioned?
Para 6, Your Honor. Yes, Your Honor. Moot proposition. That is the first point, Your Honor. Kindly refer to para 7, Your Honor, of the Moot proposition. Do I have the pen, please? Yudhishthir and Arjun have raised huge capital from the market investors and also issued bonds to investors so to cushion the green energy business. Your Honor, their major focus is on green energy business. Your Honor, coming to the next para, that is para 8. Not only is the loading threat of insolvency of the airline business a major blow as it is, but the issue is compounded by the fact that the debts of airline business are not restructured or paid out. The greater investors of the green energy business may not renew the bonds. Your Honor, our humble submission before this tribunal is that this shows these particular facts from the Moot proposition shows that their major focus is on airline business. Your Honor, as defined by the SMBC aviation case, that what is a fraud is something which is deceit and an injury to any party. Your Honor, here the injury is caused to us because their major focus is on airline business. Green energy business. They want to defraud us. They have taken the money. Now they want to go for IRP for insolvency and they want to take the benefits of old one. First they propose their RP. Then they have taken control of the CUC and now they will run the whole CRP process according to their own wills and choices. Henceforth, Your Honor, this is a clear-cut case of fraud as their whole transaction is doing injury to our rights and our interest. You have the principle.
Do we also part of CUC?
Your Honor, however, as we have mentioned, that they will have a majority share. So even if we want to propose any decision or if we oppose them, then that will not make any substantial difference.
They are disqualified, they will not be CUC.
Your Honor, that has been brought to the notice of this tribunal. We are really grateful for it.
There is no reason for you to assume that they will be part of CUC.
Your Honor, if this London tribunal gives an order sheet that the ARC is not part of the CUC, then we humbly accept, take it and we are really grateful for that. And only after that, it can be ensured that the interest of, that the revival of the company can be ensured.
Then you will not have any impediments whether section 10 or section 7 is in. Either of them.
Yes, Your Honor.
You will stick to that one.
Your Honor, our humble submission is only that section 7 is complete. Hence, to go for section 7, the section 10 is wrongly admitted.
You also said, go from that outside.
Yes, Your Honor.
So if suppose 10 is admitted and ARC is destroyed,
Yes, Your Honor.
then it's okay. Then you don't want to sell to the.
Yes, Your Honor, if their IIT view, if she is given the order sheet also, ARC will not be a member of COC, then we will have a majority vote, not we, along with the email bank and along with the other financial bank. Henceforth, the process will be the same. We will have a major say in the suit. Henceforth, Your Honor, just to I share an extension of 4 minutes to cover issue 4. Respectfully, Your Honor, if this has been accepted, then we will have a majority share in that in the COC, and we will ensure that the firm is divided. For this, we have different plans, and we will go for out of court settlement also for the exam lesson. We will talk with them. As can be as proved by a learned friend also, and as we are also contending that some major reason for this is their malicious. If they are removed, then our application will be our purpose will be coming to the fourth argument, Your Honor, fourth issue. Your Honor, that is now I shall be representing the interest of Union Bank of India. Am I clear, Your Honor? With respect to that. Your Honor, dismissal of application under section 65. I shall be representing the interest of Union Bank. Dismissal of application of Union Bank under section 65 is erroneous enough. Your Honor, our first argument in this is NCLT did not give any reasoning or any finding on the rehabilitation of errors. Your Honor, NCLT has to investigate the nature of transaction before the admission of section 10 application, as held by learned tribunal and reflect in this decision of Sri Ambika Rai, as given in my little compendium, Your Honor, page 155, para 69. In the compendium, wherein the I shall read it for Your Honor, it is clear that the adjudicating authority is obliged to investigate the nature of transaction and should be very cautious in admitting the application order to prevent taking the undue benefit of provisions of IBC to detriment of the interest of legitimate creditors. Your Honor, in this case, as a Union Bank representative, our commission is this only that they have not given any reason. And before admitting section 10, they must have given any reason. And so NCLT was wrong in discussing our application. Second argument is this, Your Honor, it is non-speaking order, unsustainable order, and the enclave has the right to reject those orders. For this, I do have a submission as given my comparative of
The
the
section 65 application is merely to seek
to reject section 10 because our contention is a Union Bank
the
representative.
65 allowing.
Your Honor, in the Katina case of the University also, the court has rejected section 10 application after finding fraudulent intent of corporate act. Henceforth, this court, by virtue of those decisions, as well as we, on relying on the basis of those decisions, have come before this bench.
So you are saying that in terms of judgments which have been based in light of those, the previous order, it brought back to status quo.
Yes, that has been given by SKF Power mentioned, and Wave Megacity. And on the Wave Megacity case, section 10 application was wrongly admitted, and court took that into consideration, rejected section 10 and admitted section 6. Your Honor, shall I need to prove how this section 10 is mentioned?
That we have just one more question.
No, sir.
So, the underlying assumption, or basic objection you have is, eventually the section 10 petition goes through, the COC will not be rightly constituted. COC is not constituted as of today. Yes, COC will be constituted. Who constitutes the COC under this? First COC.
Your Honor, we would have to constitute it.
No, you would have constituted that. So COC can be done. Who is to constitute COC?
Financial creditors.
No. But who will decide the constitution?
IRP on.
Correct. So if IRP decides that constitution, that situation is not eligible. IRP himself may decide that they are disqualified. If we decide they are not disqualified, they have a right to appeal against the order of the IRP. So how can you see some kind of advance guarantee that we should only constitute COC and that is my right to appeal?
Respect to Your Honor. Your Honor, we are not asking that we should constitute IRP.
No, you are asking they should be excluded. How can you ask for this in anticipation that they will be included?
Respect to Your Honor. Your Honor, as the ruled by different circumstances and ruled by the fact sheet, that here IRP is proposed to be is near.
So that's your apprehension.
Yes, Your Honor.
Circumstantial apprehension.
Yes, Your Honor. And we have a strong feeling that they will not, the proposed IRP will be with us with biasness, and that is why not to waste a lot of precious time.
Unfortunately, strong feeling is not a ground for appeal.
Respectfully, Your Honor, this, however, however, as proved by the different circumstances, we contend that the ordinator has filed the application maliciously, and so our submission is this only that reject section 10, and we mentioned in the order sheet that IRC must not be appointed, and their IRP must not be appointed, ARC should not be a part of CUC. Only then, as a union bank and as a, and right now I'm representing union bank, however, state bank have also the source concerned. So, like, we can ensure the development of this. That is our first submission. Do I have to say up where you are? Yes.
Like I said, we do all councils as exam council, when we used to go to work, we also used to have a very strong feeling that we get an ex parte state. But eventually we would realize what happened and we don't get one.
Shall I begin there? Therefore, in the light of facts presented, issue to raise arguments advanced, the authority said it is most humbly fair to learned tribunal. First, to quash and set aside the order of NCLT technical section 10. Second, to direct the NCLT to air section 7 to 9 application afresh, consider the section 65 application afresh, and as argued by counsel, to specifically mention the order sheet to prevent the formation of CUC without delay. Respectfully, Your Honor, and pass any other order that is valid between faith in the interest of justice in good court.
Now your last prayer, that formation of CUC without ARC, can this prayer be granted by any court?
Your Honor,
Can a court anticipate the formation of CUC and grant this prayer?
Your Honor, respectfully, Your Honor,
It's like an anticipatory rule. And if you are an estate, then you will do it.
Your Honor, shall I answer the question?
Yes.
Your Honor, under Rule 11 of NCLT, it has the power to complete justice, and that and we are people 11 representing the respondents in the present case. The seat permission to attend the bench of the options. Unsummarized options. The appellants in the present case have made certain assertions. The respondents strongly believe that the contentions put forth does not stand within law, and thus the tribunal must reject the appeal. To echo Sir Edward's words, let us consider the reason in this case, because in law there is nothing without reason. Fisher provides substantial reason to justify the case, and this present case does not affect the parties at hand, but affects the entire insolvency regime as well as the entire industry at large. Lordship, we have broadly 4 issues at hand involving significant questions of law. And we dealing for the first 2 issues within 21 minutes, and my co-counsel will be dealing with issue number 3 and 4 within 20 minutes. We respectfully reserve 4 minutes for such. Unless the Lordship requires further assistance, we will go directly to the issue of much interest. Lordship, for the convenience of the tribunal, the counsel shall be arguing 2 major sub-issues as issue 1A and 1B, as they are separately and independently of each other. The former dealing with the admission of section 10, and the second, the later talking about the treatment of aircraft cases under the code. Moving to the first issue, it is humbly submitted that the NCLT did not err in admitting section 10 application. The counsel shall substantiate the arguments in the 3 ways. Firstly, the prerequisites under section 10 are duly met. Secondly, that there is no case of malice of fraudulent intention. And thirdly, as a new argument submission, that is setting aside of initiation proceedings would be infractuous in nature. Before that, Your Lordship, we would like to clarify a few submissions for setting aside section in application would be infractuous in nature. Before moving ahead, we would like to clarify a few submissions to the counsel, but friends on the other side. They talked about this necessity of submitting section 10 application. Lordships may refer to the clarification 7, which clearly provides that all the procedural formalities have been duly met. So there is no question of going to the central government and doing the formalities. All those formalities are duly met as per in the clarification. And regarding the talking about the government schemes that are in the case of Air India or other airlines, that are not relevant in the present case because such is not provided in the proposition, and that is beyond the subject or the discussion today. Moving ahead to the submissions. And the first stage of submitting that the section under section 10 are duly met. Under the first form, there is a very clear debt and default in the present case. The Lordships may refer to para 11 of the proposition. It's very clearly established there is a debt of 5,000 crore, which is very clearly above 1 crore as the threshold provided in the IBC. And then there is a default which is also accepted by the council on the other side. And the second form of the argument is submitted that the test for admitting section 10 application is to have a prima facie test, which means that the NCLT would have looked into a prima facie level, would not need to look into the validity of the claim as submitted by the council on the other side. Your Lordship, may refer to page 19 of the complaint submitted. Your Lordships are aware the case is Unity versus Punjab National Bank. The judgment starts from page 7. However, the 11th para is para 21. Your Lordships are aware. It very clearly provides the Lordships that the adjudicating authority is only required to examine the existing or subsisting debt or default, and the application being complete, the tribunal is required to have a prima facie of the existence of debt and the inability to pay the debt, which is present in the present case. Further, Your Lordships, the tribunal by and large found the application to be valid and therefore rightfully recommended the application. Moving to the second part of the argument, Your Lordships, the council on the other side has talked about fraudulent intention and the merits, existing merits. I would like to highlight the clarify two things as first. Firstly, it is talking about Beam IRP agency as the entity. Your Lordships, here the point to note is that two arguments are here. Firstly, Beam himself is not appointed, Beam IP agency is appointed, which is a separate entity separate corporate entity is well established in the corporate laws and from going far beyond from the servant to the present case. Presently, it is very well established that there is two separate entities. Secondly, under the new article, it is pertinent to note that the dean was an auditor, and the role of an auditor, as established in various cases, for example, the ICA versus People Mukherjee, the Supreme Court case, is the auditor is a watchdog. It is very different role of an auditor as compared to a normal employee. So, employee as the board of directors and management has a very high role in the working of the normal employee. However, auditor has a very different role as compared to a normal employee. That is what our submission is. There is no way related and cannot be considered as a related party in the first place. Moving to the second thing that we have talked about is regarding the existence of a spillover effect with the unity. Just may again refer to the clarification. May refer to the clarification E. The clarification, and I'm just giving the response. The response clearly says the matter in question it very clearly provides that it has no relation. With the unity, have any effect with relation to the business of a customer. That it is very clearly something that I pointed out earlier, that it is a spillover effect of a customer that is going to the unity, the NFC business, and therefore it is our duty, and we are more concerned about the airline business, and does we want the resolution to be effective in nature, and therefore the airline business to be successful, as what they are portrayed about. Under the then moving then in submission section, under section then we talk about balance and corporate interaction, which submitting two-pronged arguments. Firstly, that the application was filed on genuine grounds without any mention of it is held in Sanjay Rajan Karate versus Mustala Limited that the degree of proof and evidence required to prove any transaction to be collusive is that the allegations are proved beyond reasonable doubt with an unimpeachable evidence. The options the outset from the affidavits have not provided any document, any evidence, document or otherwise, to prove there was a malice or fraudulent intention by the matter. We do not want it to be reached at the threshold is talking about an impossible or beyond reasonable doubt. Because at the first place they have not provided anything. So they have their own conspiracy theory. They have certain dots. They try to connect those dots and not relevant. They might be certain if they have certain transactions which are not relevant or related to the insolvency proceedings that are going on in the proceedings. Under the setting government subject, that the adjudicating authority they have rightfully dismissed section 65 application filed at the evening time of commission. So actually, it is not the case that they are pointing out this malice at the first stage in the impact. They have pointed out in the section 65, which shows that the NCLT have already dealt with this and rejected the application. And we are certain the NCLT observation was right. And the options is when there is nothing on record to suggest that the corporate applicant had filed section 10 application fraudulently or with malicious intent, the accused order by judgment authority of the said application imposing sentence time application is ought to be satisfied, which was held by the Supreme Court and the statement itself. It is pertinent to identify. We are referring to Nita Candidates versus SCAD. It starts with page number 1. The facts of the case is very clear. That there was an section and application as similar to our case. Then there was a case filed by the opponent at that side filed in section 65 application. The NCLT wanted to reject the section and application. The NCLT rejected that application. They went to the NCAT as in the present case, and the NCAT also rejected that. The facts are similar to our case. Moving ahead with options. Under third limit is very clear as well compared with something that sections and application is meant even if it is assumed that section and application is silent, it would be instructors in action. Why is option? Because firstly, that the
Firstly, that the application for initiating CRP under section 7 and 9 has already been submitted. It is only submitted. It would render no benefit if we even set aside section in application. It is well established that in order to initiate CRP section 7, 9 or 10, section D, two factors are in common, debt and default, which are satisfied in the present period and also accepted by the applicants in the present case. Therefore, and also there is a principle that once admission of application is done, the other applications get collapsed, as happened in the present case. So there is no other made by the exception dismissing other applications. Even if it is not assumed or if it is not dismissed, it will have become instructional at the end of the day. In the furtherance of this argument, Your Lordship, it is something that if we cause further delay, this would lead to further delay, and the delay in the resolution process would call to the erosion of assets. It is only subject the resolution process aims at the maximization of assets, and any delay caused shall be detrimental to the corporate, the assets of the corporate data, which shall not be allowed and it is against the essence of the corporate and the RTC itself. It is obvious that the commencement of this hierarchy, a de novo initiation shall not be allowed, and it would incur certain costs, and those expenses would be taken by the assets of the corporate, which will be detrimental to the edifice of the RTC itself. If your Lordships are satisfied with the first issue, we move to the second issue. Second sub-issue, which the appellants have not covered, is talking about whether the aircraft vessels should be part of the COC. The humble submission has been assumed that the appellants would have said that it should be included in the financial as a financial credit. However, we strongly contend that we will submit two strong arguments regarding the same. Firstly, is that the aircraft vessels do not owe a financial debt at the first place, which is required to be a part of the financial, to be a part of the COC. Secondly, that the right and interest of the corporate debtors are duly protected under the code already. And thirdly and lastly, that the aircraft vessels are subject to the provisions of the code. Moving to the first submission, Your Lordships. The constitution of COC is governed by section 21, which clearly provides to be a part of the COC, you have to be a financial debtor. As highlighted by various committee reports, IRC, DLRC, can highlight all those for the brevity. We all understand that it should be the financial creditors who should be the part of the COC. And to be a financial creditor, you have to owe a financial debt. In the present case, the aircraft vessels do not owe a financial debt, and therefore they should not form a part of this COC. Lordships, we will second from the argument, it is said, it is submitted that the rights and interests of the public
They have this aircraft.
the Lordships, what we are submitting is that the aircraft vessels do owe us amount. They are credited. However, they are not in financial credit. They owe certain amount to be financial credit, but two simple things, there should be a time value of money or a commercial. We are representing KMS Indeed, Your Lordship, we are the respondents. Indeed, to the IR. The clarifications very clearly provides the responding parties, and which includes their estimate about the IRP itself. So that is what we are representing the present.
So now what you are talking about is representing
Indeed. The clarification provides us and that is only the right one. Moving to the submissions, if you want to move to submissions. Here, the submissions that the operational rights and interests of the operational creditors are duly protected under the code. Okay. There are multiple cases, the Lordships, where if we see the liquidation going on of various airlines or various insolvency proceedings, the aircraft vessels have always been in pattern of cases, have been categorized as operational creditor, as in the present case should be. Because the Lordships, the rights of aircraft vessels as operational creditors are duly protected. The Lordship, the appellants would have contended that we have so much debt, we have so much interest, and that we recognize and duly law itself realized the same. And I like to highlight a pertinent fact here. They would suggest that we have thought about in the previous Christian would have made certain like had a structured formulation, something like this. The law is above all, and the law very clearly provides that it should not form a part of the COC because the rights and interests are really protected. I'll highlight two things here. Firstly, that the moratorium is not applicable due to the effect of NCA notification. The authors will find it at page number 292 of the compendium submitted. It very clearly provides that the moratorium is not applicable to the aircraft objects, aircraft airlines, and so on and so forth. It shows their interest or that their objects would be detrimental is not applicable to those issues. Secondly, that even if they extend the owe this much amount, their seat in the meetings of the committee of creditors is duly protected. Since they owe 25%, which is more than the 10%, they will have a seat. They will not have voting rights because they are not financial creditors. The idea of having financial creditors as a part of the COC is already there. Their rights are well protected and therefore this yes, they will fall under the definition of operational creditors of the business.
So my first question is, who will fall under the definition of operational creditors?
All those people who are into the business, I'll put it very simply in general parlance. The financial creditors are those creditors who owe a financial debt, which means they give into the capital of the business, such as the banks, which give money or which we call as time value of money or the commercial effect of borrowing to the business, which help to initiate or at the larger segment of the business. And the operational creditors helps the company to run. As the word suggests, operation. It talks about the operations of the business. The aircraft lessors do not owe a financial debt, they owe an operational debt, and therefore the treatment is to be as per the code.
So who are the operational creditors?
The operational creditors could be suppliers, could be those people who works in the business of the company, who should fall under the definition of
Essentially those who have supplied you any goods or services.
as highlighted here. The suppliers could be the also.
Suppliers, goods and services.
Yes, and again, as rightly pointed out, the goods and services, the aircraft is called services. Therefore, they are fall under the category of this. And the third end of the argument is that they are separate, fall under the provisions of the IBC. We are well aware that there is a CPC, convention, we talk about. There is a recent which talks about the protection and enforcement of interest in aircraft objects, which is still not enforced. Therefore, the aircraft cases are very well under the ambit of the IBC and therefore should be restricted to the same. We will proceed to the second issue, not just further it is somebody submitted that the section 7 application filed by the State Bank of Mauritius is justified. In light of the submission, the Council has present arguments under two areas. Firstly, that the proceeding initiated by the State Bank are not best. And secondly, that the insolvency application under section 7 has been filed with illegal intentions. Under the first thing, the proceeding shall be initiated by the State Bank of Mauritius as non-S. Lordships may refer to Moot proposition your Lordship may refer to the para-photograph of memorial survey. I put directly from the memorial. Respondents. Para 41. All the proceedings arising out of RBI circular dated 22/2018 under the code are invalid. Thus, any cases initiated by the financial creditors against the debtors under section 7 of the code are solely to the said circular deemed to be faulted from the outset and shall be declared void. The proceedings being non-S cannot sustain and shall be void at initial. Subsequent proceedings based on such a phenomenon stand automatically initiated and is liable to be declared non-S. The Lordship, the appellants have said they have not relied on this circular. Lordships may refer to para 14 of the code. count of the circular, which shows they have relied on the circular. And if we assume that they are not, and they might argue that it is a statutory right, if that is the case, any person who would have filed this application based on the circular, and Supreme Court rejecting the circular.
Which para you said of your?
Para 14 elections.
Para 14 of the Moot proposition.
Indeed, elections.
14 of the Moot proposition.
Indeed, elections. Para 14 of the Moot proposition. The second last, as they have already filed Section 7 application on account of this circular. The circular is the same.
Yes.
The Lordships is to the content that it was not filed on this thing but on statutory grounds. But Lordships may seek an extension just to submit this search.
Yes.
The Lordships, what we are amending if they submit that they were based on a statutory scheme. Lordships, if that is the case, the effect of the should be nullified because everyone who has submitted the application based upon the circular would have the statutory requirements already done. Then there will be the effect of the sugar will not be in place, and therefore we are submitting that since the sugar is there and it has set the RBI circular not S, and therefore something which is not there, cannot file an application.
The Rani Sugar only said that RBI circular is set aside. That is, there is no binding on any bank now to file a Section 7 petition if the parameters mentioned in that circular are met. But there is no prohibition either. Bank can, there is no obligation, but choice is still there. The Rani Sugar says, anybody who filed a Section 7 petition, basis this circular, those proceedings are invalidated. But the Rani Sugar doesn't say that bank is supposing. Now, are we interpreting the Rani Sugar to mean that no bank can ever file a Section 7? Then? They have filed it saying that inter alia this circular is there. They may still choose to say, no, we want to go ahead with this.
Then they have to file a de novo application.
Fresh one. All right.
That is not
Yes.
applicable retrospective.
Okay.
That is as much. Moving to the second of the argument, the application was filed for purposes other than the insolvency. It is central principle that one comes to the court must come with clean hands. And Lordships, there is also the principle of stare decisis. Therefore, the sugar is applicable. And the other principle, one who comes from with clean hands. They submitted the application, refer the Lordship to para 14 of the proposition. It talks about the Duryodhan has saluted the Ashwatthama for initiation of clerical proceedings. And therefore, the Lordship, it is said that it was a malicious intent. They talked about the logic for initiation of proceedings. And therefore, the application was never about the resolution of the applicant, but for other purposes, such which we assume to be the case of motive to take over the business of the village. The Lordship, therefore, it is submitted to Section 7 application since filed with malicious intent ought to be rejected. The Lordships have no further credits to the submissions.
Yes.
Further submission issues will be addressed on no consent for the non of problems. If I am satisfied with the judgment concerns. Much appreciated.
Lordships, I shall be reading issues 3 and 4, for which I will take 20 minutes of the standard's valuable time. The Lordships, it's humbly submitted before the Honorable Tribunal that the adjudicating authority rightfully dismissed the Section 9 application filed by Finance Union. In light of this submission, the Council shall present arguments under 2 units. Firstly, that the Finance Union has no locus standi to file a Section 9 application, and secondly, that the Section 9 application was filed with ill intention. Your Lordships, under the first limb, that is Finance Union, has no locus standi to file an insolvency application, the Council shall submit the arguments under 2 prongs. Firstly, that the debt falls short of the threshold of Rs 1 crore. Your Lordships, the default is a condition precedent for initiating the CRP process. The minimum amount of default is your Lordships, they come under the definition of workman, but the thing is that they don't meet the threshold under the IBC. The minimum threshold as required in section 4 of the IBC is rupees 1 crores to file an application. And here, individually, no, the workers cannot meet the threshold under section 4. Your Lordships, in Highland Medicals versus Anandaro Medical Center, it was held that when the amount of default was amended from rupees 1 lakh to rupees 1 crore, the object was that no application for initiating CRP should be filed unless the set threshold is fulfilled.
No, but if or as a collective, the threshold is crossed. The total claim is more than 2 crores.
Your Lordships, I request you to kindly refer to paragraph 51 at page 10 of my book. I will answer your queries from this.
Just before that, let us see the facts of this aspect. Okay. Go to the Moot proposition, see paragraph.
Yes.
Indeed, Your Lordship.
That is the Moot proposition, right? Please read that. And then we will see your answer.
Yes, Your Lordship.
Please read that.
So, Your Lordships, here they say that the pilots workmen.
Last line, jointly staking a claim of 2 crores.
Indeed, Your Lordship. They are stating the same jointly, which as Your Lordships rightly mentioned, it can be jointly placed. But Your
So is there a prohibition under IBC that people cannot come jointly?
Your Lordships, the thing is, in the landmark judgment of Sadashiv Noman Nayak versus Gammon Engineers and Contractors Private Limited, it was held that all the workmen or employees cannot file a joint application by adding their amount, which is being claimed that is a corporate entity to cross the said threshold under section 4 of the code. Your Lordships, this judgment was also upheld by the Supreme Court. The same can be found at page 201 of the compendium.
Alright, good.
Your Lordships, it is submitted that each employee in the union cannot meet this threshold of rupees 1 crore. Thus, this application deserves rejection for the non-compliance with the essential conditions under section 4 of the code. Your Lordships. Secondly, in argument, the application in section 9 is rendered infructuous. Your Lordships, this expression infructuous means ineffective, unproductive, and unfruitful. In the instant case, the adjudicating authority has admitted the section 10 application filed by the corporate applicant. The admission of any subsequent application for receiving the CIRP under section 9 shall be infructuous, because once an application in section 7, 9, or 10 is admitted, the subsequent applications become infructuous. Your Lordships, further, the employees in the pilots union, the claims which they have, which Your Lordship pointed out that below, will be as pointed out that below is 1 crore, they can submit their claims to the IRP, who is appointed. Then the said IRP, he or she will then decide upon the validity and the genuineness of such claims. Thus, it is humbly submitted that the adjudicating authority rightly rejected the section 9 application filed by the pilots union.
Yes, please go.
Your Lordships, moving to the second leg of my argument, that is, the insolvency application filed. Yes, Your Lordships. Your Lordships, and the workman file a complaint under section 9. Complaint under section 9. Your Lordships, the thing is that the section 9 application is if they can file an application in section 9 of non-putting operational creditors as workmen are included under the same, but they do not meet the set threshold as I already pointed out. The set threshold is rupees 1 crore, which of course they cannot meet individually. I mean, this is the total debt is just clearly to the Section 9 application was filed with ill intention. Your Lordships, the applicant must file the application for purposes under Section 65. It is mentioned that if an application is filed with a fraudulent or malicious intent,
Which of the Section 9 application? Pilots or the bank?
your Lordship, Section 9 application has been filed solely with
Pilots,
the pilots,
okay.
bank and insurance sections.
That's right, that's the Section 7.
Your Lordship, so Section 65 states that if an application is filed with fraudulent or malicious intent for purposes other than resolving the insolvency of the corporate debtor, then such application should be dismissed. Your Lordships, malicious intent refers to the misuse of the law for purposes with which it was not enacted. Your Lordships, it is said that no relief can be provided to a person who has not come to the court with clean hands. Your Lordships, further, even if the CIRP admission petition meets all the criteria outlined, it is filed with illusive intent, not aimed at resolving the corporate debtors' issues, but for other purposes. Your Lordships, I request you to kindly refer to para 18.1 of the new proposition. I will not disagree. Your Lordships, para 18.1 states, an application was filed under Section 9 of the IV Code by the Pilots Workmen Union, who are cognizant of their effectively non-existent bargaining powers in a CIRP process on account of being operational creditors. The Lordship, sensing an opportunity shows malice. Sensing an opportunity to open the doors for backdoor negotiations with the management of Air in Singapore again shows malice. The Pilots Union seeks to arm-twist the management of Air in Singapore, shows that it was filed for purposes other than the resolution of the corporate debtor to extract as much as they could, to settle their dues outside the court by recommending an IRP, and the appellants have admitted that they want to appoint their own IRP. It shows it's a blatant misuse of the court. They are using the court for purposes other than it was intended for.
Can they appoint their own IRP?
The Lordships under Section 9 generally they can never appoint their own IRP. Of course, they will always propose their name. But the fact that they are likely to be appointed so that he or she will act in their favor shows that they are in line with the other facts mentioned as well.
But sensing an opportunity, how does that translate into malice?
Your Lordships,
Isn't it everybody's legitimate entitlement to sense an opportunity and to act accordingly?
indeed, Your Lordship.
So where is the malice involved in that?
Your Lordship, they want to open the backdoor negotiation with the management.
That's your perception.
Your Lordship,
Exercise of a legitimate right, sensing an opportunity, how does that translate into malice or fraud?
Your Lordship, sensing an opportunity is met with their intention to file. Firstly, that they want to open the backdoor negotiations with the management, and secondly, that they want to arm-twist the management of Air Singapore to settle their dues outside the court. Shows that never wanted to be in court proceedings for insolvency.
Also, what is wrong to settle the dispute outside the court
That's right.
or to protect the interest of the
Assuming everything that you're saying is correct, how does it amount to malice or fraud?
Your
How can you
Lordship,
use these terms malice and fraud so loosely?
Your Lordship, the Section 9 application was should have been filed with the proper intent for the resolution of the
No, who
CA.
will gauge that intent?
Of course, Your Lordship.
No, what is the intent according to you? Intent according to you is to have a backdoor negotiation with the company? What is so fraudulent about that?
Backdoor negotiations and arm-twist the management of Air Singapore.
No, arm twist is your perception. You said sensing an opportunity. I don't see anything wrong with sensing an opportunity. I don't see anything wrong in having a backdoor negotiation with the management. I don't think that amounts to fraud or malice.
Your Lordship, their intention to arm-twist clearly shows that they did not intend to file it for resolution of the corporate data, instead to extract as much as possible from the company.
You see, if the scope of inquiry at the time of admission of the petition is to be enlarged to gauging the intent of the petition in every case, and that too basis the perception of any objector, no petition under insolvency would ever succeed. There will be hordes of objections from people saying that the intent is not proper.
Your Lordship.
Now the only thing that has to be gauged at the stage of admission is whether the petition is within the four corners of the law. The only exception being section 65. If you can show expressly there is malice or fraud associated with it.
Your Lordship, clearly the intention to harm this shows that that they intended to file it for purposes other than redemption of insolvency, and the lessors intend to gain as much as they wanted. Your Lordship is mentioned in para 18.5, this is an established fact.
Let me tell you, 80% of the petitions that are filed by operational creditors or by financial creditors, they are least concerned with the resolution of insolvency. They are concerned with recovery of their money. So is that malicious intent or it is permissible legal intent?
Your Lordship, but the thing is, they also want to issue the corporate debtor by filing the.
No, half the petitions get resolved. Financial institution files the petition, the respondent says we make that payment, they withdraw the petition. They are least concerned whether the company would subsequently go into insolvency or insolvency.
Submitted, they want a section 9 to be admitted because they absolutely want to.
Not in this case. Now the question is, one, what is the meaning you attach to malice or fraud? Second, how far can that inquiry go at the stage of admission?
The Lordship, malice should, firstly the malice, the how far that inquiry can go is just maybe to the basic something which can provide basic document to something.
So something that is so blatant. So what is so blatant about workmen coming to court filing a petition saying that the company owes us so many dues, and the net effect could be the company may negotiate with them? So what is so unlawful about that?
Your Lordship, but
Just to supplant and add one more thought to your mind.
Yes.
Their claim is limited to their dues.
Correct.
If they were armed to speak or was there any malice, they would have increased their dues. Can they do that? They have to stick to their claim. They can't go beyond that. So where is the malice and where is the intent?
Your Lordship,
Because the claim is sacrosanct. You can't change it. It has to be there. If I was asking you for more money, if I was giving me less money, that is one way of looking at it. That will probably lead to a negotiation.
In
But I
fact,
can't ask for more money.
out of the three orders, I think the argument of malice is least sustainable for the workman.
Your Lordship, it was question and that clearly shows up.
Correct.
Your Lordship, if your Lordship know whether there is a counterfeit commission to move to the court.
Yes.
Your Lordship, it's humbly submitted before the Honorable Tribunal that a dismissal of Section 65 application filed by the Union Bank of Kurukshetra is not erroneous in law. Your Lordship, in light of this submission, the Council shall present the arguments of the three unions. Firstly, that only debt and default are to be considered to enter Section 10 application. Secondly, that Section 10 application is not filed as malice. And thirdly, there is no proof of any intention on part of the corporate debt. Your Lordship, moving to the first line of my argument, that is only debt and default are required to enter Section 10 application. It is humbly submitted as Section 10 of the IBC. The NCLT is required to admit an application if the existence of debt and default are proved. Your Lordship, here, as mentioned in para 11, the CD owes a debt of Rs 5,000 crores and has defaulted upon it. Your Lordship, I request you to kindly refer to para 22 on page 205 of the compendium. The name of the case is Pondicherry Extraction Industries Private Limited versus Bank of Baroda. It is an NLIU judgment. Are your Lordship looking? Your Lordship, quote from the judgment. But Section 10 does not empower the adjudicating authority to go beyond the records as prescribed in Section 10, and the information as required to be submitted in Form 6 of the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016, subject to the ineligibility prescribed under Section 11. If all the information are provided by an applicant as required in Section 10 and Form 6, and the corporate applicant is otherwise not ineligible under Section 11, the adjudicating authority is bound to admit such application, and it cannot be rejected on any other ground. Your Lordship, further, the NCLT correctly exercised its power in admitting such an application by not considering any other external factors. Your Lordship, now to the second name of my argument, that the Section 10 application is not filed as malice. The Council humbly submits that the simple law for imposing penalty under Section 65 is that the proceedings have been initiated to defraud any person. Malicious intent is described as a use of the law with a wrong and inappropriate motive for other purposes other than what it is supposed to be used for. Your Lordship, the applicants must file an application for purposes other than voluntary insolvency for retroactive section 65. If an application is filed in accordance with the legislative intent behind the IBC and to resolve the corporate debtor, then the said application cannot be rejected under section 65 as section 65 cannot be used to negate the business of the law. I request your Lordship to kindly refer to para 17 of the Moot proposition. Are your Lordships with me? Your Lordships, in the instant case, here Singapore had no intention to defraud, but rather it intended to do the dharma by filing the application as the end result of the same would be in line with the legislative intent behind the enactment of the code. Your Lordship, this shows that such an application was filed to comply with the law in good faith, hence the section 65 cannot be used to negate the use of the law. Your Lordship, the section 65 application filed by the NLIU-VKC is thus dubious due to the absence of malice.
So consequence, the end result will be the same if you file a 10 or 9.
Yes, Your Lordship.
What is the problem there if the 9 is accepted?
Your Lordship,
The consequence will be the same.
Your Lordship, firstly, section 10 has already been handwritten, and the corporate value asset maximization is a key section of the code. So if let's say section 10 is thrown out, now the section is thrown and admitted, then of course the person would have to start all over again. The hierarchy has already been appointed. So that delay would lead to erosion of the value of the assets. And secondly, the section application, as I already mentioned, it is not admissible as the pirates have no locus standi since they have not met the threshold limit as provided under the code. Your Lordships, further, if section 65 application is allowed, then the Union Bank of Kurukshetra would take recourse to the SARFA AC Act and sell the assets of the air in Singapore mortgaged with it.
Sorry, say that again.
Yes, Your Lordships. If the section 65 application is allowed, then the Union Bank of Kurukshetra would take recourse to the SARFA AC Act and would ultimately sell the assets of the air in Singapore which are mortgaged with it. This would ultimately kill the airline business, leaving no scope of revival for air in Singapore. This would be against the spirit and essence of the code, which aims to ensure the revival of the corporate debtor, along with securing the interests of the stakeholders.
No, but if 65 is allowed and this order is undone, simultaneously the other petition is allowed under section 9. So how will surfacing come into picture?
Well, Lordship, then of course surfacing will not come into picture. That is allowed, but we also get that section 9 should not be allowed.
So you are saying this order should stay and no other admission order should be passed.
Yes, yes, Your Lordship. Your Lordships, under the third limb, there is no proof of intention on part of the corporate debtor. The Council submits that the insolvency application satisfying the requirements of the section cannot be dismissed under the guise of section 65. The Union Bank of Kurukshetra has not proved the allegations beyond reasonable doubt with unimpeachable evidence, and no prima facie case for fulfillment of the section 65 is made out. Further, no documentary evidence has been provided to prove the allegation of Air Singapore while filing the petition. Your Lordships, the penalty under section 65 requires that a prima facie case satisfying the section 65 has been established in the opinion of the AA through documentary evidence, and it cannot be imposed if the applicant has approached the court with clean hands. On the contrary, the petitioner has come with good faith in the clean hands, since the section application has already been filed. Your Lordship, this is for 30 seconds.
Alright.
With good faith and to do the dharma in line with the vision behind the enactment of the laws of Kurukshetra. The Council seeks permission to cite the prayer.
Before that, what according to you is the standard of proof required under 65 at this stage of admission?
Your Lordship, at state petition, there should be some documentary evidence. To show. This is the prima facie case of malice. And here there has been no such documentary evidence.
So, if you apply the same yardstick, what is the proof you have cited to oppose their admission?
Your Lordship explicitly mentioned in the motion to settle back that was their intention to harm police.
So, what is the proof of that intention?
You don't read about word in isolation.
Yes. What is the
That
proof?
word in isolation. Arm twist.
So, same yardstick.
You see the yardstick like that.
And intent to arm twist could also be a collateral intention.
Your Lordship, intent to arm twist is
You see, when let's say, let me explain myself. Supposing I file against somebody, a company for bouncing of check.
Yes, Your Lordship.
The real intention is to recover my money. Collateral intention could be to teach him a lesson. Is there anything wrong with that?
Your Lordship, in the instant case, what they are doing is they are using section 9 to arm twist the management and then they want to open doors for negotiation.
So as long as the real reason is covered within four corners of law, is arm twisting an offence?
Your Lordship, arm twisting is not
Then?
in light of the facts of this case. They have, you can see the full picture, Your Lordship. This says an opportunity.
So therefore, when you apply that yardstick, that prima facie, there must be some evidence. For 65. Same yardstick, if you apply to their section 9 application, where do you stand?
Your Lordships, this is a settled fact in the position. Further, such an application cannot be even admitted since the violation has no local standard to file the application. So
That's a separate. That's a
Because
separate.
they don't have the threshold.
Yeah, they don't have the local because they don't have it.
Yes, thank you.
Yes. Your Lordships, in light of the facts presented, the question states that at the arguments advanced and the party cited, it is humbly prayed before the honorable tribunal respondents that firstly, the SCIT correctly admitted the substantial applications of AMC number. Secondly, the aircraft cases are not to be included in the committee of creditors. Thirdly, the decision of section 7 application filed by the state of Kurukshetra is justified. Then fourthly, the section 9 application filed by the pilots union was correctly dismissed. And fifthly, the dismissal of section 65 application filed by the union by Kurukshetra is not erroneous. Because of our
Your Honor, these are departments, the submissions from an audit friends from opposite side. Your Honor, they asserted that the procedural, however, this is not a procedural requirement. This is just to highlight that they did not have any intent of a fair insolvency. They came with malice in their mind. That is why they did not go to the government to seek the financial assistance. Your Honor, the second point, they said that he is not a related party. He is well and good covered under section 5 clause 24 of the Act and he is a related party. Your Honor, he has access to the books and information of the company which clearly states that he might have a bias in the future. Your Honor, as also validly raised by the bench, they have asserted that we have not provided any documentary evidence for proving our malice. However, it has been clearly stated and a settled position of law in the case of Mita Chemicals that we have to prima facie prove that it is a malicious application. Your Honor, we have presented enough evidence to show that it is prima facie malicious application. Your Honor, they have asserted that we have filed this application on the basis of the circular. However, the RBI circular specifically mentions that the threshold of filing the application has to be 2,000 crores. We only have a claim of 45 crores, so we do not fall under the threshold of the application, and we have just used the application to strengthen our point, application under section 7. Your Honor, now under section 9, they have asserted that we have a bad intention. Your Honor, the pilots union just have a claim of rupees 2 crores and it is just the tip of the iceberg in a 5,000 crore claim. We do not have any bargaining power. How can we arm twist such a big company? We have no malicious intention. So, Your Honor, it was much pleasure.
see, applicants are talking about three issues. Firstly, we talked about the intent or malice, which we have, that is not approached the government. So that's just not approaching government for the scheme that does not exist at the first place. That is not a reason for having malice. Because the good proposition never talks about there was a case in which the government allowed Air India of having certain grants. Something like this is not supposed to be argued here because there was the scope of this discussion. There is no intent or the malicious intent or fraudulent intention in this aspect. Second, we talked about we is not a related party. Not just we, as we pointed out, was an independent, was an auditor. The role of an auditor is to be a watchdog, as held in IC versus Punjab National PK Mukherjee. This is Supreme Court judgment. And as per the principle, your lordship, a watchdog cannot be considered as a person who is under the corporate itself. And therefore, he cannot be considered as to have malice. For example, if you have reported the duty of being authorized to report, there could be instances that the being has reported certain issues from the operator, and therefore it is very much possible that he was not a party but was against this. Next to Lordship, we talked about the evidences. Lordship, they have provided no material document or otherwise evidences to prove the malice. What they have done is to connect the dots, as previously also pointed out, is they have connected the unconnected dots and they have made their own theory out of the same, which is not acceptable in other case because they have to they have custom Supreme Court judgment. They have to provide an impeccable evidence which is such of a nature and meets the threshold of the same. Next to Lordship, we talked about the RBI circular. Actually, the Moot proposition very clearly has pointed out they based their application on account of that circular. Now, since the circular does not exist, the application was an issue. They have the full right to file a DMO application. They can rightfully do so, but that would again be of no effect because Section 10 application is rightfully existed already. Next to Lordships, they talk about Section 9 application, and the Lordships have also pointed out the yardstick that we talk about. The Lordships, that what we wanted to highlight here is one simple thing, that the application, they also pointed out that they do not have the capability to argue it. So they might not, but they have used the provisions of law and initiate CIRP for the purposes, and which you also pointed out was beyond the reasons of the purpose of organization in the IBC, which is to use it as a recovery tool. And it is well established that the IBC cannot be considered as a debt recovery tool. That's why this will include as functions, was an order of
जगह बताने वाला है बहुत लोग पी लेते थे, हमने कहा कोई तो छोड़ दो उस चीज़ को।
कल की तो मिल जाएगी, कल और कल हुई थी 9 बजे को उनको लेके तो येस्टरडे मैंने कल बोल रही टुमारो वाला कल टुमारो वाली मॉडल से
जो भी अगर क्लास में अगर तो या जो भी
अब उसकी नहीं लगी कोई मेरे हिसाब से
हो सकता है। हाँ तो वो तो मैं बोल रही हूँ। हाँ यार है भी अजीब भी है क्योंकि उस बार आज भी
वो एक जो इनने ऐड करेंगे ये लेके खत्म करते हैं।
हाँ भाई भाई अगर नहीं को मैसेज करेंगे मेल करेंगे।
अबे मेल नहीं करेंगे वो देखेंगे।
अच्छा फॉर्म आएगा ना। कुछ नहीं लिख रहा फोटो चिपका दूँगी नहीं उसमें हमसे मांगा गया था तब तो मेल
नहीं
इसमें हम
फॉर्म
लोग
तो अभी नहीं, शुरू में फॉर्म था, फिर मेल हुआ, फिर वापस DHRDM में फॉर्म
मैंने खाली किया कृष्ण को मारा और इसका मैंने आज पूरा खाली किया, लिख दिया, डेट लिखी, दे दिया। मैंने क्या चाहिए फोटो लगाते हैं और लास्ट साल
ठीक है भाई, ओके भाई, मैंने वो बना नहीं यार,
ठीक है सर, ये वाली एंड कर दूँ ना।